My name is Christopher Smith. I'm a civil rights attorney in Nashville, and today we're going to talk about civil rights lawsuits, Governmental Tort Liability Act lawsuits, in the context of the Christmas Day bombing in Nashville, Tennessee, that you may have heard about. And you may not have heard that subsequent to that bombing, it came out that in August 2019, the City of Nashville Police Department had investigated this bomber for a claim that he was building a bomb in his RV. And the city didn't get a warrant at that time. They didn't investigate it further. They just kind of let it go. The substance of that report was that in August of 2019, Anthony Warner was building a bomb in his RV at the address where, as it all turned out, he was in fact building a bomb in his RV at that very address. So if that had been investigated, the theory goes, the Christmas Day bombing could have been prevented. So now, can people who were injured in the bombing, can people whose storefronts were damaged sue the city of Nashville for this allegedly negligent investigation? In my opinion, the answer is no, and we'll look at it from two different ways. The first is the state court level, and the second is the federal court level. Okay, the state court level. First, let's keep in mind, you cannot sue the city of Nashville or the state of Tennessee or the federal government except in very specific limited circumstances. And the reason for that is a doctrine called sovereign immunity. What it means is the government can't be sued except to the extent that it consents to be sued. And this goes back to British common law and the notion that the king can do no wrong. And now, even though we had a violent revolution to overthrow monarchy, to overthrow the king, we incorporated some legal concepts from the British common law into our American jurisprudence, and one of those concepts is sovereign immunity. So we still have that idea. We may not have any king, but the king still does no wrong in American legal system. So the way that the state of Tennessee has waived sovereign immunity for local governments is something called the Governmental Tort Liability Act. And in certain limited circumstances, you can sue city cops for acts of negligence, but you have to show that they owed you a duty. So let's take an example. Let's say a Metro Nashville police officer runs a red light and T-bones your car. Well, you can sue them under the Governmental Tort Liability Act because that's a specific waiver, negligent operation of a motor vehicle, and they owe you that duty because they are driving on the road, and it's the duty of care of any driver in that scenario. And just like you owe the duty to someone else not to T-bone them. So that's a clear sort of example. The problem with our hypothetical with the August 2019 investigation of the Christmas Day bomber is that the police in that scenario don't owe anyone a duty. They don't owe the public a duty. And that is something called the public duty doctrine. And it means where the claim is that the police or the state actor governmental entity violated a duty owed to the public at large, the claim fails. Because you can't have, so the theory goes, the police being sued absent any sort of special relationship. So perhaps you could get around this by some intentional act, some act of recklessness, by some special legal relationship between a plaintiff and a specific police officer, but you don't have any of those facts in this hypothetical with the Christmas Day bomber. In other words, the police did not owe the owners of the Second Avenue businesses or the people who happened to be injured in this bombing any duty to investigate Anthony Warner in 2019. So something called the public duty doctrine is going to bar that claim. So that's the state court level. The public duty doctrine is probably going to bar any sort of claim by business owners or injured persons in the bombing against the city for its investigation of that bombing. What about the federal level? The federal case is going to fail as well. And the reason for that is there is no constitutional duty to protect or to rescue anyone. There's a sort of notorious Supreme Court case on this subject written by Justice Rehnquist, who essentially constitutionalized this doctrine and said that there is no background duty to rescue. And it seemed to be based on a notion of negative liberties, which is to say you have a freedom from governmental intrusion, but you don't necessarily have a freedom to governmental intervention. That's a tenuous sort of distinction, because in certain situations you do have a right to governmental action on your behalf. Most explicitly under the Eighth Amendment, prisoners have a right to adequate medical care, and the state's failure to provide it can state a violation of the Eighth Amendment. So there is something unsatisfying about the DeShaney opinion. It's been subject of quite a lot of commentary, but set all that aside, it is the law. So there's no constitutional claim on these facts that the City of Nashville police violated those constitutional rights of Second Avenue business owners or people injured in the bombing. That's unfortunate, because what do we have here? We have what looks to me to be an inadequate, possibly negligent investigation that would have prevented, almost assuredly, would have prevented the Christmas Day bombing. And yet there is no lawsuit. And that is what happens when you have sovereign immunity. You cannot proceed except in very narrow circumstances. And our law firm, we've handled lots of governmental tort liability and civil rights cases. You know, we can find ways, but the facts have to be right, and they just aren't right in this scenario. So that's it. I hope you enjoyed it. I hope it was helpful. Comment down below with thoughts or questions. Again, my name is Christopher Smith. I'm a civil rights lawyer in Nashville.